because Switzerland had to adapt his legislation to European law to be able to work with partners in the European countries. So we have these directives, and then I think what is the strongest part probably of the European labor law is all the anti-discrimination legislation. We have this anti-discrimination acts concerning foreigners, that if you have a worker from another European country, maybe a Swedish person comes to Germany and has equal rights. And then also, and that is probably newer, we have, I say we because I'm also a European citizen since I'm German and not only a Swiss. The European Union has this anti-discrimination directives concerning equal rights in gender, and also, and that is quite new, age. So the age discrimination, if you fire somebody because he's already, or he or she is already 50, you must be very carefully, because then there can be sanctions for the employer. But the rest is still in domestic law, I would say. Yeah. Thank you.
Well, thank you, Bettina. Maybe a little explanation. You referred to legal form of directives, but this directives are not directly applicable laws, but they impose on the various member states a time limit by which these directives have to be implemented into a national law. And by the way, for those people who are litigators, if this time limit is passed and the country has not implemented its terms, then the directive becomes directly applicable. So any citizen can use it to make his or her claims. Karl, would you like to answer the question?
Yes, I mean you're absolutely right. Of course, that the parties need to. I mean, you need to consider whether you need to have some clauses. The problem is, for example, if one party wants to leave or if the parties don't agree. The problem is, in my opinion and in my experience, that the first issue you have to resolve is that the lawyers understand what they write, and that's not always the case. The second thing is that the lawyers have to understand what they write in respect of its implications down the road. That is also quite difficult. And if you talk about a joint venture, it's a different story than, for example, a sale and purchase agreement. Once you've signed it, you're no longer partner with that, or closed it, you're no longer partners. In a joint venture, you're partners for a long time. Things change, exterior factors change, the parties change, the owners of the parties change, etc., etc. So when you advise a client, you must know the implications of that particular smartly drafted clause for your own client 10 years down the road, and that's kind of difficult. So my only point is, don't make these clauses too complicated. I agree with you that certain rights of first refusal and basic things you of course need, but and there may be situations, of course, where these smart clauses are good, Texas shootout or a Dutch auction or whatever. But you need to know if they really are good for your client in this particular juncture. That's difficult.
Well, I can only, thank you, Karl, concur with you from my experience as a lawyer as well as an arbitrator. In the latter capacity, you obviously deal with a case you haven't seen before, you weren't involved in it at all. I've come across the most incredible things. For example, one joint venture of some 15 banks in Europe, plus an insurance company from the United States and another bank from Japan. They didn't provide for anything in terms of something not working so well. So there was one of the 15, and it in fact happened that with his only 3% could block because they required, or major decisions required unanimity, and so At the drafting stage, I think you're very well advised to ask the parties, all the parties, the 2 or 3 or how many there are, whether or not they want to be able to continue the venture, even if only one is going to be left. And saying that, you also, of course, then have to find a mechanism, a definition of how you pay out the other parties, or how the other parties can throw you out. It has to be determined in advance through some formula relating to the results of the company over so many years, so that everybody will at all times know, okay, if I get thrown out, I will at least make this much money. Or if I want to throw X or the other one out, I will have to pay this much money. Questions? Edgar.
If I may share something with you, perhaps we have been speaking until now about private investments or investments in private companies. But since India is celebrating its constitution, I cannot resist the pleasure of sharing a fact about the Swiss constitution as well. And you may wonder, what has the constitution to do with corporations? Well, in Switzerland, it has something to do, because Axel mentioned it earlier. We vote in Switzerland about everything, about every 3 or 4 months, and almost every of these votes concerns the constitution. Not all of them, but a good proportion. And in March this year, Swiss voters have included in the constitution a provision about the compensation of executives in listed companies. And so now we have directly in our fundamental law the provisions for say on pay of top executives of Swiss listed companies. We have mechanisms that encourage shareholders to vote at the general meeting of the shareholders of listed companies. We have enhanced transparency with a compensation report that is mandatory for listed companies. And we even have prohibited forms of compensation. The payment of certain amounts is now prohibited directly by the Constitution, and the Constitution provides for criminal sanctions for that. Well, I don't believe that criminal sanctions are going to be very effective. I don't think that they are very scary in the way they are drafted. But I think it's interesting that we take that at constitutional level, and I had been an advocate for the fact that this does not belong to a constitution, but now it belongs to ours, and this was just a fact to share on the National Law Day here.
Then I cannot resist the comment to say that Sweden is probably better as an investment country than Switzerland.
Okay, how about Sri Lanka?
I will keep quiet since we are the closest.
Now, any questions? Well, if that is not the case, then I thank my fellow panelists for their wonderful contributions. I thank INBA for inviting us to this conference in this fascinating city, which is Delhi, in this wonderful country, which is India. And of course, when I say that we are thanking INBA, that effectively means Kaviraj Singh, who is just a wonderful organizer and friend. Thank you.
I think we were effective in time, actually.